Okay, today we're going to talk about business combinations and businesses combined in various ways. One simple way is for one firm to purchase the assets of the other firm, if they completely buy all the assets. But there are some things that have to be considered there. Normally debts have corporations have debts, and therefore there may be some need to compensate that. But you can actually purchase all the assets and come away with none of the debts, in which case the corporation purchasing the assets just gets bigger and the other corporation kind of disappears. Then there's mergers. This is where two firms combine, oftentimes becoming a new firm with a totally new name. And in that case, that new firm would basically have the assets and liabilities of both of the old firms typically. And there's also something called a short form merger, which is usually used when there's a subsidiary and the corporation is going to absorb the subsidiary within itself. And then there's the consolidations, which is where two or more firms all decide to combine, and usually they would maybe take a new name, but they could just keep one of the old names if it had value. So there are even mergers where the acquiring firm basically decides that it wants to have the name of the acquired firm. Okay, and so these kinds just kind of there, and sometimes the mergers, the firm will still exist in name, but be maybe owned by this other firm or combined with it in some way. So there's just all these various kinds of things, consolidations. Okay, so all those are kind of what the firms do. Then there are tender offers. Tender offers can be either friendly or hostile. A friendly tender offer is negotiated usually between the directors, and both directors agree to the purchase of the stock of the shareholders, and the shareholders are given the opportunity to buy shares in the firm that is going to be succeeding the firm that's being sold on the stock market. So we'll talk about that. Then there are those tender offers that are hostile takeovers, in which case the directors are opposed to the tender offer, and we'll talk about that in some depth. And so directors have an obligation to all the shareholders, and therefore they have to make sure that all the shareholders' interests. Some people even say that directors have an obligation to the communities that are affected by that. So the community of the workers, the consumers, the state, the county, the city that it's in, all have some claim on the assets according on the corporation. That corporations have to be good citizens, so to speak, and have to consider these interests as well. And therefore, the directors have some obligation to maybe protect the corporate entity itself and make sure that the community isn't damaged by this takeover by this firm. And so that can sometimes lead to hostile takeover. Usually if there's opposition from the directors, there will be charges by the acquiring firm that the acquiring firm will charge the target firm. It will charge its directors with being only looking out for their own interests. In other words, that they're just they're opposing it just simply because they want to get something out of it. They want to get golden parachutes, or they want to get money from it, or they want to maintain control because they're able to make more money that way, and that the acquiring firm is not a raider, but is actually a beneficiary to the shareholders. Now you've seen these, maybe if you've seen some movies like the Wall Street movies, okay, with Charlie Sheen and others. Yes, there's the questions about whether or not the acquiring firm is a good thing for the shareholders, good thing for the employees, a good thing for the corporation. And so directors have a responsibility to look after the corporate entity. How wide is that? That really kind of depends upon who you're talking to and what their beliefs are in terms of corporations. So there are some differences of opinion. So we'll be talking about that for some bid. Okay, but let's start at the beginning. Purchasing of assets. If substantially all of the corporation's assets are purchased, then the selling firm's board must approve and must obtain the approval of the shareholders. Of course, if it's going to sell all of its assets, the acquiring firm needs only to get the approval of the board of directors, usually. And now the board of directors could run it before the shareholders. That'd be up to them, though they don't necessarily need to get the approval of the shareholders. They need to, follow the business judgment rule, and that they have to be doing it in good faith for the benefit of the corporation and out of loyalty to the corporation and in the best interest of the shareholders and the firm. And I say that I always add "and the firm" because it's not simply the shareholders, and it's certainly not just the majority shareholders. They have to look out after the interests of the minority shareholders. So in some cases, you might have a firm which has a substantial number of employees who own shares in the stock. What are their interests? And what would they be voting for? How much do the directors owe to those people? Those people maybe built the firm in a lot of ways, and therefore they feel that they have a substantial stake and should be appreciated. And on the other hand, their financial stake isn't maybe that large, even though all of them maybe own some part of the corporation. They're just small people, and they don't necessarily have a lot of stocks, even as a group. But of course, now in some countries, the employees play a major role in large corporate entities. They would do that maybe in a corporate entity, or they could do it in other kinds of forms. There are other ways of forming an aggregate form of government. You can have a firm that is not a corporation that is still operating similar to a corporation. That's maybe it's solely owned by the employees, and so that can be the case. And of course, if that's the case, if the employees are the owners, then they have complete control because they own substantially the firm, and they have that in places like Germany and France. Not so much in England or America. Okay, so the acquiring firm needs only to get the approval of the board of directors and purchase of assets, and there are some issues as to debts. So the firm may find it necessary and expedient to assume the debt or assume some of the liability for the firm. The acquiring firm is not liable for the seller's debts and liability unless it impliedly, expressly assumes this debt. So it has to agree to take on these debts. If it assumes the debt, then it is deemed tantamount to being a merger. Even though it's not technically a name a merger, it's just like a merger, because in a merger you would get the debts of the corporation. Buyer retains, maybe, in which case the buyer may retain actually the seller's personnel and continue the same business. So one of the things in a merger is how are the directors and officers of the acquired firm, how are they going to be treated? What will be their role in the new firm? So there may be some promises made, and so this can be a source of litigation. Is the sale meant to defraud the creditors, whether it's whether they're buying the assets of the firm or whether they're merging? There's this issue of whether or not are the debtors, are the creditors being treated fairly, and so is it a fraud on the creditors, so to speak? So is the sale meant to defraud creditors? Fraud? Well, maybe, and so that sometimes is an issue. Mergers, a combination of two or more corporations with one surviving and absorbing the other. And so after the merger, only one corporation exists. So I draw some Venn diagrams here, and I got ABC Incorporated and XYZ Incorporated, and they're merged, and maybe you have then just ABC Incorporated. Or maybe they decide to have a new name. Or in some cases, it's the target firm whose name, like I said, survives because it maybe has a lot of cachet. So certainly a name like Disney, household name, do you really want to eliminate that name? You want to maybe keep it in some form. There might be a firm that owns it, but you'll still maybe have things that are called Disney, and you'll see that frequently with these large corporations that are well known and have been in existence and have a certain cachet to them. So I had these Venn diagrams showing that. Results of the merger, you'll see them when you see the PowerPoints that will be with the slides. Results of the merger. The surviving corporation has all the rights, assets, liabilities, and debts of both firms. So that's what happens in a merger, as opposed to a purchase of assets. Its articles of incorporation are deemed amended to include the changes stated in the articles of merger. So the very articles of incorporation get changed usually in this process, because oftentimes you're now engaging in businesses that you didn't engage in before, so that may need you to change some statements in your articles of incorporation. Were you an airline firm and now you're acquiring a railroad? Well, you're still in transportation, right? Or maybe you're going to be some sort of conglomerate and you want to diversify, and so you're an airline firm, but you're actually buying something that's just totally unrelated to airlines. You're buying some agricultural firm. Okay, what's that got to do with airlines? Now, you might have some sort of diversification if the airline acquires maybe some resort firm, so a resort firm that owns maybe hotels, so that people would be able to call up the airline and make a complete package with them, and the airline could offer them a complete package. We'll fly you to your destination, and when you get there, we'll make sure you're comfortable in a very nice suite with our our firm, which is maybe a well-known firm. You keep the name of the old firm because it oftentimes has things, and so that's what you do. Surviving corporation has all the rights, assets, and liabilities, so you need to make maybe some changes if you're going to diversify, certainly. Consolidation. Two or more corporations combine to create an entirely new corporation. After the merger, all the corporations cease to exist and a new corporation exists in their place. So you'll see this in a lot of consolidations. Might be a conglomerate where you have different firms that are not necessarily related to each other. I mean, it's one thing for an automobile firm to be acquiring a firm that supplies parts that become part of the automobile. So GM acquires a company that has a really great transmission, and it's going to use those transmissions in its car. So it's why is it acquiring this firm? It's in order to get the patents and the right to produce this very nice transmission that this firm has, and maybe other things that this firm has that will be very nice for it. And it's a vertical kind of thing where they're acquiring something that's would have been maybe one of their supplier, and then in the process they may be actually cutting off or charging other firms more money for the same product that they're able to put in there. And you can see this with all kinds of firms. Microsoft might do that, and Microsoft has done that. And so consolidation. And so I got a Venn diagram for that too, showing three firms: Ape Incorporated, Bird Incorporated, Cat Incorporated. I don't know how did those get together, huh? And then they combine and they become Dog Corporation. Okay, a new corporation exists out of the old. We call it Dog. Right? So I mean, that's just the reason I chose those names was just to give you an idea of how different it is, or how it would be changed that you just take on a completely new name, and that maybe it's a completely new firm. It's a conglomerate. Conglomerate is a firm that acquires a lot of different firms, and there's a certain advantage to being a conglomerate. You can ride through maybe some economic storms better as a conglomerate, where you're not tied to one specific industry. And sometimes certain storms are really affecting one industry more than another. So for instance, right now we have the COVID-19 going on, and that's affecting the airlines because people don't want to fly in these planes in this narrow space, and they're worried about getting that. Even though the airlines have taken all kinds of precautions and done all kinds of things to reassure passengers that it's safe to ride, so they put in ventilation systems, and they have seating, where people are not being seated apart. And I'm sure they'll give you a mask if you don't have a mask before you board the plane, and probably at no charge. You in some sense you've already paid for it, and they're happy to do that. And these airlines oftentimes do have actually hotels that they're connected with, and so they're willing sometimes to sell you the airline ticket cheaper, and they figure they'll make it on the hotel, maybe, or the hotel may give a lower price in order to help the airline, and so that's up to the board of directors. They make these strategic decisions. Results of consolidation. Surviving corporation has all rights, assets, liabilities, and debts of all. So when you are that conglomerate, so you wind up having to pay the bill. And there's an issue there as well. Does the new management, does it have the competency to really manage this firm, which is kind of like put together from different kinds of parts, where there are different issues in different industries? And normally you would have, in old line firms, you would typically have somebody who came up in the industry. So Ford always only made cars, and that's what he knew. He knew cars, and he was very good with making cars. Okay, he wasn't so good in marketing. Okay, but he was good at making cars, and so he maybe wouldn't have been interested in being a conglomerate. But like I said, it can be advantageous in terms of weathering financial downturns. Okay, and one of the things is the surviving corporation, its articles of corporation are deemed amended to include changes stated in the articles of merger. So, so you have articles of mergers, and therefore you may not have actually amended your articles of incorporation, but you might need to, if you're an investor, you might need to look at the articles of merger to see whether or not there are changes to how the firm's going to operate in that articles of merger that haven't appeared yet, maybe in the articles of incorporation, but may in the future, and probably should in the future, if they're going to be operating that way. Procedures for combining. Merger or consolidation is proposed by one of the parties. The boards vote to approve or reject. If approved, a shareholder meeting is called to vote on the merger. So remember, the directors have an obligation to all of the shareholders, and many people say they have obligations. They have a duty to the greater interest in the community of the community and the nation, and therefore they should be considering that too. If approved, a shareholder meeting is called to vote on the merger. So they're not going to merge without a vote, but they might refuse to merge, in which case the other firm might decide to conduct a hostile takeover. A merger plan is filed with the Secretary of State if they've agreed upon it. The state then will issue a certificate of merger or consolidation, depending upon whether it's a merger or consolidation. Short form mergers. A substantially owned subsidiary can merge with its parent corporation without shareholder approval. If the parent owns at least 90% of the subsidiary's outstanding stock, it can do a short form merger, which is very quick and easy, and you can understand that their issues are different. Now, even in a short form merger, though, you could have dissenting shareholders who could call for certain rights that they would have under that, the right to dissent to the merger, and basically a right to get money for their shares, actually, to demand that, I didn't want to be a member of that firm. I bought into this firm, and now I'm going to be, absorbed by that, and maybe you're going to give me some shares. I don't want your shares. I want my money. Okay, and in case you might, this is called appraisal rights. A statute might allow shareholders, so depending upon the state that it's incorporated in, a statute might allow the shareholders to dissent and demand this right. If a merger or consolidation is approved, like I said, that would have to be done by the majority of shareholders. So you see the minority shareholders, might be just even one shareholder, has a right to demand his appraisal rights. Sale of all corporate assets not in the ordinary course of business. Amendment, or whether it's a merger or consolidate, or even where there's a sale of all corporate assets not in the ordinary course of business, a shareholder might, depending upon the state, have some appraisal rights to get his money out of the corporation. Doesn't want to be acquired. Amendments to the Articles of Incorporation. They may have some rights to demand certain amendments to the articles. Whether any appraisal rights exist depend on, usually it's just a matter of money. It depends upon the state of incorporation, like I said. Procedure to exercise appraisal rights. The shareholder files a written dissent to the proposed transaction, whatever it is, merger, consolidation, whatever it is, he has to write his written dissent to them. If the transaction is approved, the shareholder must make a written demand for payment of fair value. So this is not going to be a market price. This is going to be a price based upon experts who decide what the value of those shares are. Because oftentimes these firms are not, that are owned 90% by the parent corporation, they're not being traded on the stock exchange. Most of the shares are in the hands of the corporation, and it's not selling shares. So there's very few shares out there that are not. And the shares that are out there are usually held with various agreements that would prevent them from being sold separately. And if they were sold, the other people, including the parent firm, would have some right to buy up those shares. They would have a right to preemption to buy up the shares. We talked about that in a previous lecture. Okay, so transaction is approved by shareholders. It makes a written demand for payment of fair value. Like I said, you know, he can bring in his own people to evaluate. The corporation will bring people in and give him an estimate of the fair value, and he doesn't have to just roll over and take that. He can challenge that by getting his own experts, and then you might have a court case, or you might just simply negotiate it. Fair value. Fair value is the value on the date the vote is taken. Okay, that's the vote when they do the merger. The corporation must make a written offer to buy the shareholders' stock. If fair value cannot be agreed upon, then a court will set it after a hearing. So the court would have to hear it and would hear the testimony of both sides, and the expert witnesses of both sides would, you know, maybe contest the values. Purchase of stock. Purchase of a substantial number of voting shares of a corporation stock enable an acquiring firm to control a target corporation. So this would be a tender offer. And this is there are Securities and Exchange Act laws that apply, federal laws that apply to this, and sometimes there are state laws. So a state like New York has a lot because it has the Wall Street corporate, you know, it has the stock exchange there, and you know, it has a lot of things, and it actually is very active sometimes in litigating and regulating the stocks of corporations. And it has a lot of firms that are incorporated in New York, being the biggest state maybe that way. Delaware also has a lot, but you know, that's because it's oftentimes has very much looser regulations, a lot more freedom for the corporation and its directors and its owners, in some sense, may have some things that they like about incorporating in Delaware. Then you have corporations that choose to incorporate in a state like Indiana because of connections they have there. They grow up there, they start it there, and they just want to be an Indiana firm. So purchase of stock. So this is one thing. The acquiring corporation deals directly with the shareholders to buy their shares. So they're going to buy it directly from the shareholders, unless, of course, they can get the firm to agree to a merger. And you know, so the tender offers. A tender offer is a public offer made to shareholders to buy voting shares, which, if accepted by enough shareholders, will allow the offerer to take over all the corporation and to buy everybody's shares. So you know, if you don't want to be acquired and you vote against it, or you don't sell your shares, eventually you may be forced into selling your shares, and maybe you'll be given the right to then acquire shares in the acquiring firm. The offer usually turns on the receipt of a specified number of shares before a specific date. So if you're going to be taken over, oftentimes there's a bonus for, you know, there's a benefit to actually selling your shares. So, and sometimes there is poison pills as a defense. We'll talk about that in a minute. The price offer. The price is often much higher than the stock's market price before the tender offer. So when a tender offer, when the market becomes aware that a firm is going to be acquired, oftentimes the stock gets bid up. And you know, that's maybe a lot of that might just simply be on speculation. And you know, some things may be coming out that weren't previously known. And so oftentimes it will be bidden up, and sometimes that's encouraged by the target firm that wants the stock to be bid up. and it may resist and try to get a better deal for the shareholders that way, or simply to preserve itself. And that's, of course, the argument of the acquiring firm is that these directors are just looking after their own interests, or looking after their own jobs. If they're acquired, they're going to lose their jobs maybe, and they're trying to negotiate and get better deals for themselves from the acquiring firm. That's, you know, something that, you know, has to be looked at. So, I mean, they have a duty on it. So we need to talk about the Williams Act. This is a federal law designed to protect shareholders from fraudulent tender offers. So, you know, the directors and the acquiring firm, besides the directors opposing the acquisition, they might actually be in league with, and, you know, basically in a plot to basically take advantage of the shareholders. And so federal law is designed to prevent that. There are disclosure requirements that have to be made when there is these tender offers going on. Any person making a tender offer must file with the SEC and disclose thereby specific information regarding the tender offer and related matters. And they're also required under this act to buy the shares of all the shareholders who tender shares, even before and after the firm has acquired the thing. But after it has acquired substantially enough firms to control it, it may be forced to buy shares from shareholders who were otherwise resisting it. Tender offers must remain open for a minimum of 20 business days. So, you know, they have to buy all the shares at that offer price. So if they we got to make a good deal, get people to buy the shares, and the people who maybe initially don't want it won't buy it right away, but they got 20 days, you know. So in that 20 days, if the firm doesn't sell enough of its shares, the merger doesn't happen. So it has to acquire a certain percentage before the merger is there. So there might be fraudulent, deceptive, and manipulative conduct involved, and that would be unlawful if that's the case. And actual misrepresentation or other deceptive misconduct must be shown. So you have to have evidence of that, whether it's the acquiring firm that's engaged in misconduct or the the selling firm, or both of them get together. You're going to have to prove those things, and so you'll need access to the records. A board response. The directors must make a good faith recommendation as to whether the shareholders' acceptance or rejection of the offer would be most beneficial. So they are required to make a recommendation, and they'll make it one way or the other. And, you know, in some cases they might say, no, they're offering too low a price. And, you know, directors oftentimes maybe know things that even the acquired firm theoretically doesn't know, or maybe it does know it, but doesn't, you know, how it knows it, nobody knows how it knows it. Some sort of corporate spies, James Bonds in the corporate world. Directors must fully disclose all material facts, both supporting facts for their decisions and the facts that appear to be adverse to their decisions. So they need to do this disclosure to the shareholders, so the shareholders know what the situation is. There are tactics, anti-takeover tactics. When the directors oppose the takeover, they often will engage in different kinds of tactics. So this is a list of the kinds of tactics that are used, and these are some of them. So self-tender offer. So that's where the firm itself offers to buy the shares of its shareholders. So don't sell your shares to this acquiring firm. Sell it to us. We'll put it in the treasury. You can, whatever shares you keep, you'll still have an interest in the firm. On the other hand, if you really want to get some money and sell it, we'll buy it from you. Self-tender offers. So basically, the acquired firm competes with the takeover firm, and so it's obviously a hostile takeover at that point. There's also a tactic of selling something which would be called the crown jewels. In other words, this is a very valuable asset that maybe can be exploited in the future. So I remember one case involved an oil field, and the director said, well, that oil field was very valuable and was going to produce a great flow of cash, and this takeover firm was not willing to pay enough to take over the firm because it would be acquiring this very valuable thing, and so it sold that very valuable oil field to some other corporation, and then distributed the profits to its shareholders. Basically they began off by saying, well, you'd be better off by not selling to them And so we recommend you not sell your shares, because in the long run you're going to make a lot of money off that oil field that we have. And so those are the kind of things that are going on sometimes. And why is a firm going to acquire another firm? They must be doing it because they think they can make a lot of money. And you know, if they indeed know that there's some sort of valuable asset that is maybe not even known by the shareholders, that's just being secretly held, you know, for strategic reason by the firm, they're maybe not exploiting it just yet. And so the question is, are they making the right decision by not pumping out that oil? You know, they're saying, well, in the future that oil will be much more valuable than it is now. Anyway, poison pills. Poison pills are provisions that are added to the corporation and added that when the firm acquires, if they are being acquired by another firm, there's something that firm may have to do, like pay money to the shareholders. And so poison pills are designed to discourage the takeover. Okay. Are they being done in the interest of the shareholders, or are they just being done in the interest of the directors? And of course, the takeover firm is going to charge. They're doing it because they're trying to preserve their jobs and their interests. They're not doing it for you shareholders. We're offering you a good price for your shares, and we're acting in your interest. You should sell to us. So you will have this kind of disclosures being made. There'll be basically a propaganda campaign going on by both sides. Pac-Man. Pac-Man is sometimes a firm that's attempting to acquire a firm might have itself caught up by the firm who goes out and finds financing and they acquire them. So you know how it is with any of you who have played Pac-Man. It's an old game. In Pac-Man you would chase the ghost and the ghost would chase you. And sometimes when the ghost was chasing you, you'd turn around and you'd capture the ghost. And sometimes when you were chasing the ghost, it'd turn around and capture you. That's Pac-Man. Okay, and so that's what it is. White Knight. White Knight would be another firm that acquires the target firm. You know, and so the directors make a deal, and you know, and they get this other firm to acquire them, and so they weren't able to reach any sort of agreement with the acquiring firm, and they just make some sort of deal with this White Knight firm that's going to, according to them, give a better deal to the shareholders, and certainly maybe also give a better deal to the directors also. So it's that way. Greenmail. I think this has disappeared. This tactic has just disappeared. Taxes make this unlikely. Greenmail would be paying off the acquiring firm. So you take money from. So you know this firm's going to acquire your firm. You're a director, so you pay them money to go away. So they call that greenmail. Is that in the best interest of the shareholders? Doesn't seem likely. And so there are a lot of taxes involved in that make it unlikely that you would do that. So it was largely a criticism that was raised against greenmail, that it was never really in the interest of the shareholders, and you can understand why. You're just paying off the firm. And what are you preserving? The director's jobs, the director's interests? That's about it, right? So, you know, the director's not supposed to be acting in their interests. They're supposed to be acting in the interest of the corporation, corporate entity, and that includes the interest of, obviously, the shareholders, and therefore they ought to be not paying greenmail. Injunction on antitrust matters. So if there's an injunction issued, and maybe the acquired of the firm that's being targeted, maybe they work with the government and, you know, provide information to the government, and the government may want to stop a merger or an acquisition because of the concentration in the market. So if there's only a few firms, let's say, in a certain entertainment sector of the economy, there's only a few firms. There's 3 big firms, and then one firm is going to acquire one of them. Well, then you're going to only have 2 firms, and you're not going to have the same sort of competition. And so, you know, so the government may oppose it. And, you know, that may be done in part because the target or somebody else, you know, voices an objection. Maybe somebody who's not the third firm that's not really part of the deal is maybe going to complain. And so, you know, so sometimes the government will step in on its own, or maybe with encouragement from somebody else in the particular market that we're talking about. Okay, so there's an interesting case in the book called Air Products Incorporated versus Air Products and Chemical Incorporated versus Airgas Incorporated. And this is a Delaware firm, and so it's reported in the Atlantic Third reporters, which are reporters that report on state matters. So, the Federals, have their own reporters, and so this is why that's in there. So you see this peculiar, listing of being 16 Atlantic Third, page 48, 2011. So this is a relatively recent firm merger or attempt to acquire a firm. So Air Products and Chemicals Incorporated wanted to acquire this Airgas. Air Products and Chemicals is a big firm, actually, much larger, I think, than Airgas ever was. Directors owe a fiduciary duty to all the shareholders. So I'm just summarizing what the case was about. And so you have to look at this firm and you have to realize that what directors are doing, they say they're doing it because of all the shareholders, that it's not really in the interest of minority shareholders. Directors had a good reason to believe, and so the shareholders would need to be informed on why they were doing this, but the acquiring firm doesn't necessarily need to know this, although they may already know, which may be why they're trying to acquire the firm. And the directors had good reason to believe that $70 a share was too low, and a reasonable belief in thinking that. So a majority of the shareholders would, and they also had a reasonable belief that a majority of the shareholders would accept the low tender offer. Why? Because a lot of the people basically don't really understand a lot. They may know quite a bit in the firm, but they may not really understand the issues involved with this thing or the values involved. And forcing the minority to sell for too low a price, basically. So these people would basically buy it, even though they could maybe make more money if they took it along. Maybe they believe that, maybe they don't believe that. Maybe they're persuaded by it. Maybe it's just too complicated for them to actually decide on. Maybe there's just different ways of looking at it. And so it might be disputed whether or not it's actually worth more or not. But the firm had done a good job of acquiring experts to testify and had good reasons to believe that it was actually worth more than the $70. Now, this Air Products and Chemical Incorporated tried to acquire Airgas the previous year and had been unable to do so. But they had managed to get like 3 directors on the board of directors. And the interesting thing was those 3 directors that Air Products and Chemicals Incorporated put on there voted with the majority of the directors to oppose the sell at $70 per share. So, I don't know, traders, I guess. I don't know how that goes down. But anyway, so they apparently were persuaded that it was in the best interest of the shareholders as a group, and that might include an interest in protecting the minority shareholders who wouldn't sell, who predictably might not sell. And so this was a major decision because the acquiring firm was going to trot out there are experts who always argue for the market, that the market should make the determination. So they're always opposed to the idea that the directors would be blocking the acquisition using a poison bill, especially with a staggered board. So you have a staggered board here. So I mentioned before that if you do have a staggered form board of directors, the shareholders cannot, in one swell swoop, change that board of directors. You're going to have to maybe have 2 or 3 elections before they can actually get enough people on the board to change it, depending upon how it's staggered. And so combining so there's an argument that combining a poison pill defense with a staggered board could result in a case where a firm can not just simply say no to the proposition of a takeover, but can say never. That sounds unfair, right? But is it? If it actually is in the interest of the best shareholders, if they haven't actually offered enough thing. And so maybe the directors need to, every year that's being, so in the previous year they were offering $65 a share, and they were able to resist that, and now they're offering $70 a share, and so their tactic in some sense had benefited all the shareholders in that they were now being offered more money for their shares, was it even worth more? So they were saying it's worth 73, and the firm wasn't willing to put up to 73. Instead, they decided to litigate it, and they lost. Forcing the minority to sell for too low a price is really not something that you should take too lightly. So even the directors who were put on the board by the acquiring firm didn't decide to do that. And the firm was getting a lot of support from its own banks and had financial support to oppose this. The directors did their duty in maintaining the poison pill, according to the court, that it was absolutely justified. So the boards, the judges in Delaware have lots of experience in these things and have a well-developed set of laws on this. And basically, they're well aware of the division in experts between those who support the acquiring firms and those who support the resisting firms. Okay, and so there are people like there are scholars that come in. So Marty Lipscotch, I don't know. Lipston is actually a person who actually supports this position of the board of directors who resist it, and saying that there are situations in which they should do it, that their duty requires them to do it in some situation. And this, according to the Delaware court, was one of those situations where they were justified in doing it, and it was in the best interest of the shareholders, and probably not just simply the minority, but certainly maybe in the best interest of the minority shareholders. And they have a duty to look out for all the parties, and if it's actually more valuable and they can drive up the price, why shouldn't they be able to do that? Why should it just simply be a matter of, well, let the market decide, which is what the other scholars will say. Let the market decide. So you have these people who are market nuts that will always want the market to decide everything. And I know that I would say most financial scholars and most financial people who teach in the colleges that I've been to are more interested in letting the market decide, and I'm not so sure that that's always the best situation. And I'm also inclined to think that it's not merely the shareholders that need to be considered, it's also the employees and the communities. Termination. Dissolution can be voluntary or involuntary, so one firm may decide to dissolve itself, and so and the directors might be the ones who apply for the dissolution. So the liquidation might be, an action may be brought for liquidation by a board member or by a court-appointed trustee. So if a corporation is having some financial issues, the court may, who is going to maybe deal with it in bankruptcy. That is that maybe it's been hauled into bankruptcy, and there are maybe board members who are opposing the dissolution, and then there may be board members who are in favor of it. And so, but it can be brought by a board member, or it might be brought by a court-appointed trustee. So the court in these kinds of cases will usually appoint a trustee who has experience in corporate law and corporate takeovers and corporate interests. And so he knows those issues. The bankruptcy judge knows bankruptcy, no doubt, and he knows something about this entire process, but he oftentimes is going to let it go to a person who has more expertise in that field, and let him handle these issues. I think that's usually the case, because the bankruptcy judge is oftentimes mostly dealing with smaller bankruptcy, individual bankruptcies. So, yeah, and so that's dissolution. Voluntary dissolution usually begins with the board of directors. Sometimes the whole board of directors votes to dissolve, and to put the issue, if you're losing money, you're getting deeper in a hole, maybe it's good just to end it, right? So unanimous vote by the shareholders can also initiate the dissolution. So you can also put the, maybe a majority of directors put it to the shareholders to vote, and so both sides will maybe, both groups of directors will maybe argue, some directors arguing that they ought not to dissolve, others arguing that they should. A unanimous veto of a vote of the shareholders can also initiate the dissolution. So they don't have to wait for the directors. However, you remember that basically shareholders usually only vote when the directors have called a meeting. But there is an annual meeting every year. There has to be one annual meeting, so shareholders will be voting then. And they can put this on the ballot. The corporation files an article of dissolution with the Secretary of State, which is possible. That would be directors would be doing that. The effective date is the date of the article's filing. Involuntary dissolution, state. So a Secretary of State is empowered to dissolve corporation and will do so when non-compliances arise where the firm isn't complying with laws. And so there may be these issues. So the corporation is being monitored by the state. That there's a misrepresentation in the charter, so they're not doing what they said they were going to do, or they're not operating as they said they would under the charter. These may be financial issues, or it may be marketing issues, or maybe any kind of issues. So what's in their charter and what aren't they doing that they're supposed to be doing according to the charter? So they're supposed to follow the charter. Ultra vires acts, these are abuse of power. These are acts that are not justified by the charter that has been filed. And so the corporation is governed by that charter that it filed. It's got to live up to its promises. Incorrigible violation of criminal law. Talking about the Ultra Vires Act, there was this one case where the guy was not, he had a plan of selling eggs of that big bird. What's that big bird that comes from Australia? And so basically he was going to sell these eggs, and people weren't interested in buying the eggs, so his marketing efforts failed. So he decided to take the money of the corporation that they had in their treasury and go to the racetracks. And of course he lost it. And that's an abuse, that's an Ultra Vires Act. He's under his charter, he wasn't supposed to be doing that. He was supposed to be engaged in this business with the eggs, not doing that. And it's also a violation of criminal law. And so didn't commence operations. In some cases somebody will say he's going to do a certain business, but he won't even start the business. Didn't commence operations, and the state will then bring action because you're not doing what you were supposed to be doing. Abandoning the operation prior to start. So you take the money and you go to Europe. That's not legal. Can't do that. It wasn't given to you. Involuntary dissolution. Articles of incorporation might empower any shareholder to dissolve for specified reasons. For example, death in some states. So there will be state statutes that allow a shareholder to kind of dissolve the corporation. A petition by shareholders for, some issue. A petition that the board is deadlocked in irreparable harm is probable. So the shareholders themselves can, because it's deadlocked and things are all frozen, can, file for dissolution. So it's a legal action. They usually have to go get a lawyer to do that. Mismanagement or breach of trust. Liquidation. After payment of all debts and sale of assets, the residuary cash, the cash that's left over, is distributed to the shareholders. Liquidation may be by the board of directors or by a trustee appointed and supervised by the court. And that's what's happening in bankruptcy, usually. So the board supervision, where the dissolution is by voluntary action, the board as a whole or a part of the board might wind up the business of the corporation. Even if a bankruptcy gets filed, the judge might decide that they might be able to do a better job because they know this business better than anybody because this was their business. And so he might decide that it would be in the best interest of all the shareholders and of all parties if they did the dissolution rather than a trustee. Because you have to find a trustee who knows this particular business better than they do. Court supervision, and he'll only do that if he thinks that they are not responsible for any of the things going on and that they're honest and they have clean hands. Court supervision arises in involuntary cases where no director will act as a trustee. Maybe no director wants to be a trustee. Or when the shareholders' creditors show good cause why the director should not be trustee, then the court will appoint a receiver to wind up the corporate business, and that's the way that goes. So that's it for tonight. Thank you very much. I hope you enjoyed it as much as I did. So, thank you. And I am putting off the test that was supposed to be tomorrow on the 20th. You'll be looking at this on tomorrow, and this will be on the test. And so that's, so we're not going to do the test till December. I'm not exactly certain exactly which date yet, but it'll be December, so you'll be given notice.